O.C.V. et al. V. Bondi out of the 10th Circuit on August 26 et al. This is matter of MRMS. Miss MRMS is the matriarch of this family. For some reason, she just wasn't the named petitioner in this family case. But this is matter of MRMS, the big bad BIA family nexus asylum decision that came out during Merrick Garland's board of all boards, which is just wild to me. In which the board instituted a new rule, quote, for family-based claims and family-based claims only. And by the way, this will be a bit of a theme on this talk today with these cases, that the board has been trying to create different rules for different classes when there aren't specific rules for specific things. They tried to do it with Silva Trevino and the CIMT definition. Like, there is the categorical approach, there is particular social groups, there is nexus, and then you apply that to facts. You don't get to create new rules based on family-based particular social groups. And that's exactly what the board did in matter of MRMS. Merrick Garland's board, quote, if a persecutor is targeting members of a certain family as a means of achieving some other ultimate goal, unrelated to the protected ground, like, gangs extorting, family membership is incidental or subordinate to that other ultimate goal, and therefore not one central reason for the harm, end quote. That's a new rule. Like, yes, mixed motive cases exist for asylum, but the protected ground, family membership, cannot be incidental or subordinate or tangential and qualify for asylum. The board is saying you can't have like any other reason for a family-based group. Matter of MRMS, big deal. I've been giving it no love on my show ever since it was published. It has not been faring very well in the circuits, and particularly the Fourth and the Sixth Circuit have gotten their teeth into it. But this is direct petition for review. This is matter of MRMS. It was petitioned for review itself to the 10th Circuit, where apparently it originates in one of those 10th Circuit immigration courts. And the 10th Circuit was having none of it. They flat out said that rule, that's not how Nexus works. Mm-hmm. Flat out, which is correct. And I do think indicative of how matter of MRMS is on the problem, quote, the government attempts to defend the BIA's Nexus statement, that is what I just said, by rewriting what the BIA wrote, end quote. So, like, even oil doesn't want this. And even in a generally favorable, 10th Circuit, whatever, it's not, you don't get that many positive for non-citizen decisions out of 10th Circuit. So even in the 10th Circuit, the oil's like, we don't want to do this. Like, that's not what the BIA meant. But if that's not what the BIA meant, they would have had no cause to make it precedential. Obviously, it's exactly what they meant. They wanted to do a new rule for family-based groups, and the 10th Circuit just vacated and remanded matter of MRMS. It's a huge win. Center for Gender and Refugee Studies, Perkins Coie representing the amicus of former IJs and BIA members, and AMICA, formerly the CARE Coalition. A lot of the whole community in on this one. I think David Isaacson or Jeff Hoffman did, now an IJ in Houston. That is this idea that when a circuit vacates a precedential BIA decision, that decision doesn't exist anymore. Other circuits can't rely on it. That's different from when, for example, the Sixth Circuit had already said, matter of MRMS, not good law in the Sixth Circuit, we disagree with it. Fine. MRMS exists in all the other circuits, but here the 10th Circuit has vacated matter of MRMS itself. That's different. I'm making this argument at present in an 11th Circuit case that goes to oral argument in December. Other people have been trying too. I've been talking about it for years now. It's my big nerd issue. And no circuit has yet recognized this, and I don't know why, but look at it. The 10th Circuit here kind of did. They said, quote, we cannot leave uncorrected an agency's precedential misstatement of the law because that unlawful standard governs a dispositive issue and appears in a published 3-judge BIA opinion, so it serves as precedent in all agency-level proceedings involving the same issue, end quote. And then the 10th Circuit goes on to explain why it's vacating before remanding. Why do that analysis if the 10th Circuit isn't saying that by vacating and remanding, MRMS no longer binds anywhere? It's wonky, it's complicated, but I see this as the 10th Circuit recognizing the zombie precedent argument, albeit not as fully and completely as I would like. But in any event, that's a lot. Big decision.